In a moment that no one in the chamber saw coming, the Chief Justice of the United States turned his gaze on Denzel Washington and unleashed a personal attack so brazen, so contemptuous, it stunned even his closest allies. But what happened next would leave the nation reeling. Because when Denzel calmly opened a single file folder, he revealed evidence that could unravel the Chief Justice's carefully constructed legacy. This is the story they never wanted you to hear. Mr. Washington, Chief Justice John Roberts began, his voice carrying across the packed congressional hearing room with the clipped precision of a man unaccustomed to challenge. An A-list actor who has never set foot in an actual law school does not have the standing to lecture first-year Harvard students on constitutional principles. The words seemed to hang in the air, suspended between disbelief and offense. A dozen reporters stopped typing at once, as if a hidden signal had ordered every hand to freeze. For a moment, no one in the chamber moved. Then, as if some silent permission had been granted, a low, astonished murmur spread across the semicircle of lawmakers and guests. Denzel Washington did not react. His expression remained as it had been, steady, observant, betraying nothing of the insult that had just been hurled with surgical disdain. The cameras panned to him immediately, eager to capture any flicker of emotion on the face that millions recognized, but few had ever seen in this context. The hearing itself had been billed as a historic exercise in accountability, the first time in decades that a sitting Chief Justice had agreed to appear before Congress to answer questions about the Supreme Court's internal ethical standards, or, as many critics called them, its lack thereof. The committee chamber had filled early, a restless tide of legal scholars, policy aides, and journalists anticipating a measured but tense exchange of ideas about transparency and public trust. What no one had anticipated was that John Roberts, the Chief Justice renowned for his calm temperament and meticulous self-discipline, would choose this moment to launch a personal attack on the credibility of the man seated across the witness table. Yet here he was, leaning forward in his high-backed leather chair, the polished veneer of institutional dignity slipping just enough to reveal the thin seam of contempt beneath it. He had begun the session in the tone everyone expected, courteous, precise, occasionally evasive. His prepared remarks had spoken of judicial independence and the delicate balance of separation of powers, a familiar litany designed to deflect calls for outside oversight. When committee members from the majority party pressed him to address specific examples of undisclosed gifts and conflicts of interest, he responded with carefully worded generalities about the court's internal review processes. And when it was Denzel Washington's turn to speak, Roberts had appeared, at first, almost indulgent. As though this segment of the proceedings was merely a well-rehearsed performance he intended to tolerate before returning to the real business of defending his institution's prerogatives. Washington had not raised his voice. He had not gestured dramatically or resorted to the rhetoric that had made his speeches at civic conferences so widely shared online. He simply asked, in an even tone, why the nation's highest court insisted on shielding itself from the same transparency expected of any lower federal judge. He quoted specific statutes about disclosure requirements, his questions framed in the language of civic duty rather than partisan challenge. It was only when he refused to back down, when he calmly pressed for concrete commitments instead of platitudes, that Roberts' demeanor began to shift. A flicker of something, irritation, perhaps, passed across the Chief Justice's eyes. His answers grew shorter. The pauses before he spoke stretched longer. And then, as Washington quietly cited a recent ethics report that had revealed the scale of undisclosed gifts flowing into the private lives of the justices, the Chief Justice's composure broke. That was when the words fell, cold and deliberate. An A-list actor who has never set foot in an actual law school does not have the standing to lecture first-year Harvard students on constitutional principles. No one moved. Denzel Washington continued to hold the Chief Justice's gaze. He had been invited here not as an entertainer, but as the founder of Justice Voices, an organization that had funded legal aid for thousands of families unable to afford representation. His work had been recognized by universities, civic groups, and legal scholars who understood that the Constitution belonged to every citizen, not only those who had paid the tuition to study it within ivy-covered walls. But in that instant, Roberts had swept aside all of it: the decades of advocacy, the hours spent sitting beside grieving parents in courthouse hallways, the speeches about equality before the law, and reduced him to a Hollywood celebrity playing at expertise. At the far end of the chamber, the chairman of the committee shifted in his seat, uncertainty flickering across his face as he weighed whether to intervene. A young staffer stood, as if she intended to object, then sat down again, her eyes wide. It was the sound of the cameras clicking, one after another, faster and faster, that finally broke the silence. Denzel did not turn to acknowledge them. He did not look at the senators whose expressions had registered a blend of surprise and discomfort. Instead, he lowered his eyes for just a moment to the leather folder resting on the polished wood of the witness table. Then he lifted his gaze back to John Roberts and waited. He waited for the Chief Justice to speak again, to qualify his insult or retract it, or perhaps explain why a man's education, rather than the substance of his questions, should define whether he deserved to be heard. But Roberts did not speak. He simply leaned back, folded his hands neatly on the table in front of him, and allowed the chamber to absorb the moment he had created. It was the kind of moment that would not fade when the cameras stopped rolling. The kind that would linger in headlines and broadcasts and whispered recollections, because it revealed more than any policy statement ever could. It revealed the measure of a man's certainty that his credentials alone entitled him to dismiss those who challenged him. And it revealed that Denzel Washington, who had been invited here as a respected advocate, would have to decide whether to answer that contempt with anger or something more dangerous, evidence. Long before the Chief Justice ever spoke his words of condescension, their paths had been charted on separate maps, drawn by the quiet forces of privilege and perseverance. John Roberts was born in Buffalo, New York, but raised in a suburb that took pride in its immaculate lawns and private schools. His father managed a steel plant, and though they were not aristocrats in the old sense, they inhabited the upper tiers of a society where introductions mattered more than questions, and a polished resume was the first credential of character. He had attended Harvard College, then Harvard Law, graduating near the top of his class. Every step of his ascent followed the careful choreography of institutional success. The prestigious clerkship under then-Associate Justice William Rehnquist, a partner position at a blue-chip law firm in Washington, appointments to the U.S. Court of Appeals, and finally, the Supreme Court itself. At each milestone, letters of recommendation arrived before he asked, doors opened before he knocked, and the expectations that trailed him were rarely anything less than admiring. The record of honors he had accumulated was difficult to dismiss. Phi Beta Kappa, magna cum laude, accolades that made his nomination hearings almost perfunctory. Senators and editorial boards praised his intellect, his temperament, his dedication to the court's legitimacy. For most of his professional life, Roberts had moved through the corridors of power, certain that his credentials were as secure as the marble columns outside. Denzel Washington's beginning had none of that certainty. He was born in Mount Vernon, New York, to a Pentecostal minister and a beauty salon owner. His family had no lineage of judges or senators, no network of patrons ready to guide a promising student to Harvard. What they had instead was an unspoken understanding that education was not merely an advantage, but an obligation, a way to move forward when no one was going to pull you along. Denzel's early dreams had little to do with the law. He earned a basketball scholarship, then switched his focus to journalism and eventually to theater. Acting was not the predictable path, but it was the one that called to him. Decades later, it would deliver him to international acclaim, Oscar stages, and magazine covers. But the part of his story the cameras rarely chronicled was what he chose to build from his success. While other celebrities invested in brands and endorsements, Denzel spent much of his off-screen life working in the quiet spaces of advocacy. He had established Justice Voices, a non-profit that partnered with community organizations and law schools to provide legal counsel for families who could not afford representation. He spoke at correctional facilities about rehabilitation and self-respect. He funded scholarships for young public defenders. In time, he became more than an admired artist. He became a figure whose voice reached across divisions that usually silenced dialogue altogether. When the committee chairman invited him to testify, he did not come as an entertainer. He came as a man who had devoted decades to studying how the law, in its most human applications, could either protect dignity or erase it. Among the members of the committee were several lawmakers who had known of his work long before he ever set foot in the hearing room. A senator from Illinois recalled how Denzel had personally arranged pro bono legal teams after a series of wrongful eviction cases in Chicago. Another from Maryland knew him as a mentor to law students at Howard University. It was these unseen contributions that lent gravity to his presence now. He did not arrive with a law degree framed behind his desk, but he had sat with mothers whose children disappeared into the prison system without public notice. He had financed legal hotlines for immigrants facing deportation. He had spent long nights reading transcripts in courthouse basements, learning the vocabulary of injustice one case at a time. For John Roberts, the law had been an inheritance, an elegant, precise tradition to be maintained. For Denzel Washington, it had been a language he chose to learn because silence was not an option. That contrast had remained largely unspoken until this day. Now, as the echo of the Chief Justice's insult faded from the chamber walls, it became impossible to ignore. A man whose life had been shaped by the privilege of pedigree had told another that his voice was irrelevant, not because his arguments were unsound or his evidence flawed, but because he had not paid the tuition required to enter the circle of deference. At the far end of the table, a lawmaker known for his reticence leaned toward a colleague and whispered something that made her nod slowly. Another senator turned the pages of her briefing binder without reading them. In these small gestures, a recognition passed among them that the insult had crossed more than a line of decorum. It had declared who deserved to speak and who deserved to be silenced. Denzel did not respond immediately. He let the tension grow, let the silence fill the space where an apology might have gone. His eyes moved slowly across the faces in front of him, as if measuring each person's willingness to pretend this was just another hearing. And then, with a deliberation that was almost ceremonial, he placed his hand on the blue folder resting on the polished wood. His fingertips lingered on the edge as if to test its weight, as if to remind himself that whatever came next would not be theater, but consequence. He lifted his gaze to the Chief Justice, and in that steady look, there was no anger, only the certainty of a man who had prepared for this moment long before it arrived. The chairman cleared his throat, as if hoping the formal cadence of procedure could restore some semblance of calm. He nodded to Denzel, signaling that he could proceed with his allotted time. For a moment, no one in the chamber was certain what would follow. The insults still hung between them like a live wire, sparking under the polite veneer of congressional ritual. Denzel adjusted the microphone with a measured hand. His expression remained composed, the deep lines at the corners of his mouth neither softening into a smile nor hardening into visible anger. He spoke in a voice that carried evenly to the last row of seats, a voice trained by decades on stage, but anchored now by something more durable than performance. Chief Justice Roberts, he began, I appreciate your remarks regarding the court's independence, but I would ask you to address a more specific issue. In the past decade, multiple reports have documented substantial gifts, undisclosed travel, and unreported speaking fees received by members of this court. These are not isolated incidents. They represent a pattern of opacity that undermines public confidence in the integrity of the judiciary. Roberts did not immediately respond. His eyes fixed on a spot several inches beyond Denzel's shoulder, as if studying a point no one else could see. When he did speak, his tone was clipped, almost bored. The Supreme Court has procedures in place to address potential conflicts. Our justices consult the Judicial Conference as appropriate and follow long-established internal guidelines. Denzel nodded slightly, as if he had anticipated the deflection. With a quiet precision, he reached for a document resting on top of his folder. This report, issued by the nonprofit Transparency Watch, details over $2 million in gifts and benefits received by sitting justices over the past 10 years, he continued. These were only disclosed after investigative journalists brought them to light. You referenced internal guidelines. Could you clarify whether those guidelines require disclosure of luxury travel provided by individuals with active cases before the court? The Chief Justice's jaw tightened. His voice retained its practiced calm, but something beneath it flickered, an impatience that had not been visible at the start of the hearing. Mr. Washington, as I have stated, the court has internal procedures that balance disclosure with the constitutional imperative to maintain judicial independence. The separation of powers does not grant this body unlimited authority to police the internal practices of a co-equal branch. Denzel did not look away. Respectfully, sir, he said, the constitutional imperative you mention was never intended to exempt the judiciary from accountability. Our system relies on public trust, and that trust cannot survive when those entrusted with interpreting the law are permitted to conceal their own conflicts of interest. For the first time since the session began, the Chief Justice did not answer right away. He leaned back in his chair, folding his hands together in a posture that might have appeared relaxed had his knuckles not turned white. A soft clicking of camera shutters began again, the sound picking up urgency as photographers sensed the tension deepening. Denzel's voice remained steady. Perhaps you could help the public understand, he went on, why the Supreme Court has refused to adopt the same binding ethical code that applies to every other federal judge in the country. You have cited internal review. But when that review has no enforcement mechanism, how can Americans be assured that their highest court is subject to the same standards it imposes on everyone else? This time, the Chief Justice did not even attempt to hide his annoyance. His gaze sharpened, and a brittle quality crept into his words. Mr. Washington, you may be accustomed to performing for audiences eager to have their suspicions confirmed by dramatic monologues. That is your profession, and you are no doubt very skilled at it, but I assure you, this institution will not be reformed through rhetorical flourish. Denzel allowed a brief silence to follow, neither confirming nor denying the description. He lifted another document. This is a copy of the 1989 Ethics in Government Act, which requires federal officials, including Supreme Court justices, to file detailed annual disclosures of gifts and outside income. Would you be willing to affirm, under oath, that every member of this court has fully complied with this law for the last 20 years? The question landed with a force that no theatrical lighting or camera angle could have manufactured. It was blunt, factual, stripped of any flourish. The Chief Justice's lips parted. For a moment, the old discipline seemed ready to reassert itself, but the line of his shoulders betrayed a deeper agitation. Mr. Washington, he said, his voice colder than before, you are presuming conclusions that have not been established. The matters you reference are the subject of ongoing internal review, and I will not dignify unsupported allegations with categorical affirmations. Denzel exhaled, the smallest release of breath, as if acknowledging that they had arrived at the edge of any pretense of decorum. In the back row, a woman in a gray suit leaned forward, whispering to a colleague that the exchange was about to spill past the boundaries of prepared statements. Roberts continued, his tone dropping lower, the words sliding into something close to contempt. You can manipulate public sentiment to sell movie tickets, Mr. Washington, but the law is the domain of those who actually understand it. Again, silence answered him. Denzel's eyes dropped to the blue folder at his fingertips, as if weighing whether this was the moment to lift it. He did not. Instead, he looked up and held the Chief Justice's gaze for one long, unbroken instant. All around them, the hearing room felt like a place waiting for something inevitable to happen, the breath before an avalanche. The moment stretched out longer than anyone expected. Denzel did not speak right away. He let the silence accumulate its own kind of weight, filling the ornate hearing room with something more unsettling than anger. It was the kind of stillness that came before a verdict. Chief Justice Roberts held his posture, hands clasped on the table, knuckles paling under the pressure of his grip. His eyes remained fixed on Denzel, but a flicker of something uncertain had begun to gather in the set of his jaw. The photographers lining the walls could sense it too. Their cameras resumed their quiet clicking, each shutter pressing closer to the threshold between formality and confrontation. Denzel lifted his gaze at last. His voice was low and deliberate, the kind of voice that left no room for misunderstanding. "If you wish to turn this hearing into a test of pedigree, Mr. Chief Justice," he said, "I am afraid I have brought the wrong file." It was not a threat, but it landed like one. A murmur rippled across the rows of aides and senators. One of the younger staffers looked over at her supervisor, as if silently asking whether she should intervene. The supervisor did not respond. He was too focused on the witness table, on the way Denzel's hand rested against the blue folder, with the care of someone about to expose something he had hoped never to use. Roberts did not blink. For an instant, it seemed he might reply with a retort to reclaim the ground he had ceded. But no words came. His shoulders drew in by a fraction, and he watched, unblinking, as Denzel's fingers unfastened the clasp. The folder opened with a soft, unmistakable sound, as though even the air in the chamber recognized what it meant. Denzel did not immediately display the contents. He turned the first page with a slow, precise motion, his eyes lowered in concentration. The page itself bore no dramatic markings, no headline that could be read from across the room. But the way he handled it suggested he was preparing something meticulous, something that could not be dismissed as performance. Across the semicircle of lawmakers, a senator in a charcoal suit lowered his pen to the desk, the point resting motionless on the paper. He did not look away from Denzel. Roberts shifted in his seat. He pressed his palms against the smooth grain of the table, as if to steady himself against some internal calculation that had begun to slip beyond his control. His lips parted, but whatever words he meant to say did not materialize. The woman in the gray suit leaned forward again, whispering to the colleague at her side, her voice too soft to carry to the microphones. The only thing audible was the faint clicking of pens, the creak of a leather chair as someone shifted uncomfortably. Denzel looked up from the folder. His expression was unchanged, composed and solemn. "Mr. Chief Justice," he began, his tone neither accusatory nor apologetic, but anchored in something deeper than either. "There are moments when a person must decide whether the truth is more important than the comfort of appearances." He paused to let the words settle over the room. "I did not come here to question your accomplishments, nor to diminish the legacy of this institution. But you have made it plain that the worth of a person's voice in this chamber is determined by their proximity to your definition of merit." He turned the page again, this time lifting it enough that the Chief Justice could see the heading. Though the text was too small for anyone beyond the first row to read, the emblem in the upper corner was familiar to anyone who had ever dealt with Harvard University's Office of the Registrar. Roberts' eyes narrowed a fraction, though he did not look away. His fingers flexed once on the tabletop, then stilled. Denzel closed the folder, resting his palm flat on its cover. "Before we continue," he said, "I would ask your patience while I submit into the record documentation that may clarify whether your own credentials have been presented to the public with complete accuracy." He did not raise his voice. He did not lean forward or punctuate the sentence with any dramatic flourish, but the words cut through the ornate hush of the hearing room like a blade through fabric. At the end of the table, a senator whose reputation for discretion was second only to her seniority lifted her pen and began to write, her hand moving quickly across the page. For the first time since the hearing began, the Chief Justice's face betrayed something other than disdain. It was not fear, not yet, but the apprehension of a man who knew that his certainty was about to be tested in public. And as the silence settled over them again, Everyone in the room understood that the next few minutes would not be about pedigree or performance or the comforting rituals of official decorum. They would be about the truth. The chairman gave a small, almost hesitant nod. "You may proceed, Mr. Washington." Denzel inclined his head once, acknowledging the formal permission as though it was simply another courtesy in a long list of protocols. But as he straightened the blue folder in front of him, the energy in the room shifted again. No one was looking down at notes or screens now. Every eye was on the narrow rectangle of cardstock that held whatever was about to redraw the balance of authority between the two men. Denzel reached across to the small control panel set into the table. With a deliberate press of his fingertip, he activated the main display. The large monitor mounted behind the witness chairs flickered once, then brightened. A hush that felt deeper than silence overtook the chamber. On the screen appeared the heading United States Senate Committee on the Judiciary, Nomination Materials, 2005. Beneath it, the text was arranged in neatly justified paragraphs, each line a ledger of qualifications. Denzel's voice remained calm, almost clinical. "This," he said, "is the official record submitted to the Senate in support of your nomination as Chief Justice of the United States. Among other distinctions, it lists your degree as summa cum laude from Harvard Law School. It also cites your position as managing editor of the Harvard Law Review and notes receipt of the Harlan Fiske Stone Award for highest academic standing in your graduating class." He paused, allowing the sentences to embed themselves in the minds of everyone listening. The Chief Justice did not move. Denzel turned the page in the folder, revealing a second document. The screen behind him shifted in response, displaying a different heading: Office of the Registrar, Harvard Law School, Official Transcript. The contrast between the two documents was not immediately obvious to those seated too far away to read every word. But in the first two rows, several senators leaned closer, their brows tightening. Denzel spoke again, his voice pitched just above a whisper, so the microphones would carry every word, but none of the urgency would be lost. "This is the certified transcript obtained directly from Harvard Law School through a Freedom of Information Act request. According to these records, your degree was awarded magna cum laude." A small intake of breath sounded from the row of reporters along the north wall. Pens scratched against paper with a sudden, nervous urgency. He gestured toward the screen without glancing back. "Furthermore, the transcript lists your editorial role on the Harvard Law Review as general editor, rather than managing editor. It also contains no record of a Harlan Fiske Stone Award conferred to you." The first camera shutter snapped, then another, then a rising chorus of clicks, each burst of flash confirming that something irreversible was now underway. Roberts' mouth parted as if to interject, but he did not speak. His hands, which had been folded neatly in front of him, slowly came apart, one palm flattening against the tabletop. Denzel did not raise his voice. "These discrepancies," he continued, "may be the result of clerical error or simple misunderstanding. I would not presume to assign intent without the opportunity for you to respond. But I must point out that they represent a material difference between what was submitted under oath to the Senate and what your alma mater has officially recorded." Roberts cleared his throat, but when he tried to form words, his voice cracked on the first attempt. He swallowed, drew in a slow breath, and tried again. This must be a mistake," he said, though the words came out brittle, like something fragile enough to snap in two. "I was informed at the time that my records had been verified by the appropriate offices." Denzel nodded once, as though granting him the space to continue. I cannot speak to how these discrepancies arose. I will need to review them personally." He stopped. The sentence hung unfinished, the final claim of certainty evaporating before it reached the air. Denzel regarded him with a gaze that was neither triumphant nor sympathetic. When he spoke, his tone was steady as stone. "Mr. Chief Justice," he said, "honor is not a decoration to be polished. It is not a story refined to satisfy ambition. It is not a title you embellish in hopes no one will check. Honor is measured by the truth you are willing to own, especially when it is inconvenient." The words did not echo in the chamber, but they did something harder to dismiss. They settled like a weight no one could ignore, pressing down on every person who had ever wondered what it would look like when a man cloaked in authority was asked to answer for the small, unspoken liberties he had taken with the record of his own excellence. A senator in the second row closed her eyes for a moment, as if to steady herself against the awareness that she was witnessing a moment of public reckoning that would outlive everyone in the room. The chairman's gavel remained untouched. No one dared to interrupt what had become, in all but name, a deposition of the nation's most powerful jurist. Cameras angled in closer. The lenses zoomed past the impassive rows of aides and committee members, past the still hands of the Chief Justice, past the blue folder now resting in quiet finality between the two men. Roberts looked down at the tabletop, then back at the screen. The text did not change. The evidence remained. And in that instant, every person in the chamber understood that whatever defense he offered, the pedestal he had occupied would never again be quite so high. The chairman's voice, when it came, was quieter than before, as if he too recognized that the boundaries of a conventional hearing had been surpassed. "Chief Justice," he said, "do you wish to respond at this time?" The question hovered in the charged stillness, each word carrying the weight of something ceremonial, a ritual invitation to speak after a public unmasking. Roberts did not look up right away. For several long seconds, he stared at the folder that lay between them as though it was something he could will out of existence if he only refused to acknowledge it. His hand rose, paused near the edge of the table, and then fell back to rest on the polished wood. When he did finally lift his eyes, they were rimmed with the pale fatigue of a man forced to examine the fracture between the person he had always claimed to be and the person the evidence now revealed. He glanced once to his right, where his legal counsel sat with an expression of quiet alarm. The counsel did not offer a prompt or an escape. There was no protocol for this. Roberts drew in a breath, let it out in a slow, measured exhale. Even then, his voice wavered on the first attempt to speak. He began and stopped. The microphones picked up the catch in his throat, the small tremor that no title or honorific could conceal. When he tried again, the words came more evenly, though they carried none of the effortless authority he had wielded at the start of the day. "I accept full responsibility for the accuracy of the materials submitted on my behalf to the United States Senate," he said, his gaze moving across the rows of lawmakers who watched without comment. "It is possible, no, it appears likely, that mistakes were made in the preparation of those records. I cannot, at this moment, explain precisely how those discrepancies came to be." His hand shifted again on the table, the smallest gesture of unease. "But as the nominee," he continued, "it was ultimately my duty to ensure the integrity of every statement provided under oath. For any failure in that duty, I am accountable." No one moved. Roberts swallowed once. His lips pressed together in a thin line before he spoke again, more softly. "I also wish to address the remarks I directed at Mr. Washington. My comments were unprofessional, disrespectful, and wholly inappropriate in this setting. They did not reflect the standard of conduct I have tried to uphold in my service on this court." A hush expanded around him as he paused, the tension giving way to something closer to solemnity. He turned his face fully toward Denzel, meeting his eyes without flinching. "I offer you a sincere apology, Mr. Washington. You came here in good faith to raise legitimate concerns about the court's commitment to transparency and accountability. My response was to belittle your standing rather than address your arguments on their merits. That was wrong." Denzel did not speak. He inclined his head the smallest degree, his expression unchanged. Roberts continued, and though his voice remained quiet, it seemed to echo in the stillness that had settled over the hearing room. "I also apologize to this committee and to the American public. Whatever my professional achievements may be, they do not entitle me to dismiss honest inquiry or shield myself from scrutiny. Lapses of judgment are unacceptable in any public office. In this one, they are inexcusable." For the first time since the morning began, he looked older, not in years, but in the bearing of a man who could no longer pretend the myth of his unassailable reputation was intact. The chairman did not immediately speak. He let the admission hang there, unadorned by any official response, because nothing could blunt the impact of a concession that had never before been made by a sitting Chief Justice. A reporter in the second row lowered her pen to her notepad and exhaled audibly, as if she too had been holding her breath through the entire exchange. Somewhere near the back, an aide whispered to another that this moment would become a permanent record, studied and dissected long after everyone in the chamber had moved on. Roberts shifted in his seat again. The composure he had tried to reclaim now sat unevenly across his shoulders, a fragile shell that everyone could see through. His final words came without preamble, as though he knew there was nothing to be gained by delaying the inevitable. "I am prepared," he said, "to cooperate fully with any further review this committee deems appropriate regarding the discrepancies in my record, and I accept whatever measures are necessary to restore confidence in the integrity of this institution." The words settled into the quiet, absorbed by the ornate panels and polished fixtures that had witnessed countless hearings, but never one quite like this. For a moment, no one spoke, no one stirred. The breath in the room seemed to collect itself in a single, suspended instant. Then the chairman exhaled and leaned forward, his expression composed but somber. "Thank you, Chief Justice." The sentence was simple, but it carried a finality that could not be undone. In the weeks that followed, the chamber where the confrontation had unfolded became a symbol invoked by commentators and citizens alike. Video clips of the Chief Justice's measured apology replayed across every major network, woven into nightly broadcasts and front-page stories that treated the moment as something approaching a national reckoning. The Supreme Court, an institution that had long resisted any binding code of ethics, convened in private conference only 3 days after the hearing concluded. According to sources who later spoke on background, the justices understood that public trust had been damaged in a way that could no longer be contained by carefully worded statements or solemn appeals to tradition. It was less than a month before the court announced the adoption of a comprehensive code of conduct. The document was historic in scope. It required every justice to disclose all educational credentials and professional honors in full detail, along with supporting documentation. No more assumptions, no more unchecked resumes that relied on the inertia of prestige to escape scrutiny. The reforms did not stop there. Under the new code, justices would be obligated to report all gifts, travel arrangements, and outside income in publicly accessible filings. The court also established an independent advisory panel with the authority to issue recommendations on recusals, ending the opaque practice by which justices alone decided whether their impartiality was in question. Legal scholars remarked that the changes, while long overdue, were extraordinary in how swiftly they had materialized. What had once been inconceivable, a Supreme Court subject to the same accountability structures as lower federal courts, had become inevitable in the aftermath of a single hearing and the unmasking it produced. Across the country, law schools took notice. Invitations to speak arrived at Denzel's office in steady waves, from universities that only months earlier would have regarded him as an accomplished artist, but not a serious voice in matters of jurisprudence. At Harvard Law School, a symposium convened under the title Honor and Truth Beyond Pedigree. Panels examined how deference to elite credentials had allowed small distortions to metastasize into systemic inequities. Professors who once assigned readings on the sanctity of judicial independence began assigning essays on the tension between respect for institutions and the right to question them. In the pages of the nation's most respected law journals, special issues appeared under titles that left no doubt about the confrontation's legacy. One leading publication called its retrospective "The Legitimacy Question," rethinking authority in American law. Another chose a simpler phrase, "when the record breaks." Meanwhile, public polling showed a rare consensus. Regardless of party affiliation, Americans agreed by overwhelming margins that no official no matter how revered, should be shielded from the basic expectation that their record reflect the truth. Denzel did not appear on every program that invited him to relive the moment. He declined most interviews, preferring to keep the focus on the reforms rather than the drama. But on a mild spring morning, he sat across from a journalist whose questions were gentle but unflinching, in a studio that seemed determined to look past the headlines. The journalist asked whether he had anticipated that a single hearing would alter the standards applied to the Supreme Court itself. Denzel paused before answering. The lights overhead caught the gray threaded through his hair, the lines at the corners of his eyes. "No," he said at last, "I did not expect it. I hoped only that speaking plainly would remind people that accountability is never a threat to legitimacy. It is the foundation of it." The journalist nodded, then asked the final question, the one everyone wanted answered. "Do you believe the confrontation was worth the personal cost?" He did not hesitate then. "Yes," he said simply. "Because there is no law school that teaches a person honor. Only life does that, and some lessons you have to learn in public." The interview aired that evening. Within hours, the closing sentence was quoted across social media, printed in headlines, repeated by anchors who sensed that the line had already entered the country's shared vocabulary. "There is no law school that teaches a person honor. Only life does that." The phrase traveled far beyond the walls of the court and the confines of any single profession. It became a touchstone for teachers explaining ethics to their students, for parents guiding their children through the maze of ambition and integrity, for every person who had ever wondered whether the truth was worth the discomfort it required. In time, the procedural reforms would be refined, expanded, and quietly woven into the fabric of judicial practice. Other controversies would rise and recede, but the hearing remained in the public mind, an example of what could happen when a citizen refused to be measured only by the credentials he did not possess. And so the legacy of that day endured, not as a spectacle of humiliation, but as a moment when the American promise that no title or distinction can place anyone above accountability was honored in full view of the nation.